3, 2, 1, 0. All engine running.
There is no other institution that has the ability uniquely
Without a heritage, every generation starts over.
Ask not
to remind the current regime
what your country.
We, the people, tell the government what it is allowed to do.
to get back in their box and stay there.
Liftoff. We have a liftoff.
From the Heritage Foundation, this is Heritage Explains.
In November, several high-profile elections are taking place across the country. Americans will cast their vote for governors, attorneys general, mayors, and a host of other public officials. For most, participating in these elections will be as easy as showing up at their polling place, casting their ballot, and being on their way. But we take the ease of modern voting for granted. For instance, for a black man living in the American South in the early 1960s, voting may have been fraught. Black Americans faced poll taxes and literacy tests meant to keep them away from the polls. They faced intimidation and threats. Some faced harm to life and limb. The Voting Rights Act of 1965 was a federal law designed to end these practices and ensure that all Americans could exercise their right to vote. It's a law that has had massive impact and been used to reshape America politically in ways both good and bad. Now, the Supreme Court is hearing a case called Louisiana versus Calais, which is calling into question how part of the Voting Rights Act is being interpreted. Here to talk about what makes this case so important is Hans von Spakovsky, Senior Legal Fellow here at the Heritage Foundation. Hans von Spakovsky, welcome back to Heritage Explains.
Well, you must be a glutton for punishment, Mark. You've invited me back.
I know. It's good to have you back. And for folks who may not know, we want to talk about some election integrity and voting rights issues. That is your bread and butter. For folks who may not have tuned in before, tell us a little bit about what you do here at Heritage vis-a-vis voting rights and election integrity.
Well, I'm the manager of our Election Law Reform Initiative, which for years has been working to try to persuade states and sometimes Congress to put in election reforms that we believe actually that have been proven to improve the integrity and security of the election process.
So the reason that we're talking today is because this past week, a lot of folks were paying attention to some oral arguments that were happening at the Supreme Court
Right.
In a case called Louisiana versus Calais. There was a lot of attention given to this because they're discussing a fundamental change to the Voting Rights Act of 1965. Why is this such a big deal?
Well, actually, I don't think it's so much a change as I think what they actually should be doing. I mean, that's the way it was presented. That and certainly if you read some of the mainstream papers, well, left-stream papers like the New York Times, they're all predicting, the Supreme Court's going to gut the Voting Rights Act. No, the problem with the Voting Rights Act is it's been misinterpreted and frankly abused by federal judges now for quite a while. Here's what this case was about: Louisiana versus Calais. Louisiana, like every other state, redistricted, drew new districts after the 2020 census for its 6 congressional districts. They created one district of what they call a majority-minority district. It's basically a district in which black voters are majority. So if they agree on the same person, they can elect their candidate of choice. They were sued by the NAACP and others saying, you got to create a second black majority district because we're a third of the population of Louisiana. So it's only fair that we get 2 of the 6 seats. A federal district court judge agreed with the NAACP and told Louisiana, you need to draw up a second black majority district. So Louisiana did that. They got sued again. This time by a different group of voters saying, well, wait a minute, you used race as the defining factor when you drew up that second line. That's how you figured out what the boundary lines would be. You can't do that. That's discrimination. It's a violation of the Equal Protection Act of the 14th Amendment, and that's not allowed. And 3 judges agreed with them. So here Louisiana has one judge saying, we got to draw this district, and you got other judges saying, no, you can't do that because you used race improperly and illegally. That's what was before the Supreme Court. It actually was up there in their last term. But when June rolled around this past summer, rather than issuing a decision in the case, the Supreme Court said, we want to hear arguments again. And that's what they heard last week. And what they asked the parties to brief them on was, when, if ever, can race be used, certainly under the Voting Rights Act, to draw up political districts? When is it a violation of the 14th and 15th Amendment? So that's what the case was about. I actually think the big mistake that was made in this case was that, look, Section 2 of the Voting Rights Act bans discrimination in the voting context. But when the original plaintiffs sued the NAACP, they didn't show that there was any current discrimination in New Orleans. Yeah, there was discrimination many, many decades ago. Their only justification for saying they needed a second seat was the proportion of black voters in the population. And the problem with that is that Section 2 specifically says it does not guarantee proportional representation. That is not something guaranteed by our Constitution. It's not guaranteed by Section 2. So I am hoping what happens is the court will come back and say, you can't use race at all unless you are fixing current intentional racial discrimination. And look, the other big problem this there, Mark, is that a lot of judges just fail to distinguish between race and politics. If you're drawing lines based purely on politics, the way voters vote, that's perfectly legitimate. That's not unconstitutional. But a lot of judges will look at that and go, well, yeah, you drew a district that's all democratically leaning voters, but gosh, a majority of them are black. You must have been engaging in racial discrimination. And that's not the same thing at all.
Why do you think this statute has been misinterpreted for so long?
Frankly, lazy judges who don't apply the law correctly, and frankly, a lot of very biased judges who are buying this argument of proportionality. If we're Hispanic and we're half the population, why we have to get half the seats in a district. And that may sound like that's fair, but it's not. Like I said, our Constitution doesn't guarantee proportionality based on race, and I think judges have just been abusing it, and they've been pushed to abuse it by groups like the NAACP and others like that.
This has obviously caused a bit of an uproar.
It has.
Why is it such a big deal?
Well, it's such a big deal because you have all these folks arguing, like the lawyer from the NAACP who was at the Supreme Court, that, oh my gosh, without the Voting Rights Act forcing black majority districts to be drawn, why no black candidate will ever get elected to Congress. Well, of course, the problem with that was pointed out by the Deputy Solicitor General of the United States. He was there arguing. He said, well, there's something like 60 African Americans elected to the U.S. Congress. Only 15 of those came from majority black districts. The problem that the Democratic, this is really being pushed by the Democratic Party. I mean, I hate to say this because, if a black candidate loses, if you look at the political makeup, if they're a Republican, they're winning. The problem is if they're a Democrat and they're running in a Republican stronghold. The other thing about this case was, I just couldn't believe I heard this, was the newest member of the court, Justice Brown Jackson, said that basically she thinks there's nothing wrong with using race to draw up political districts as long as it's benefiting African Americans. And this is needed because she compared black voters to disabled Americans who are protected under the Americans with Disabilities Act, which is, Mark, I'm not sure I can think of a more patronizing attitude than that. I doubt that Senator Tim Scott, who's the African-American U.S. Senator elected in South Carolina, would appreciate a comparison like that.
It's hard to imagine anybody would.
Yeah, it would. It would. But that was the view of this justice of the U.S. Supreme Court.
So if this case is decided, and we expect it, of course, to be decided by the end of this term, so this coming summer, this coming June.
Right.
This could have real implications for the makeup, particularly of the House of Representatives. Can you talk about that?
Yeah, it could. And I think the key thing here is going to be about a decade ago, the Supreme Court decided another big Supreme Court decision. And they threw out a different provision of the Voting Rights Act called Section 5, which required pre-clearance. It required a small number of states like Alabama to get approval from the U.S. Justice Department before they could change any of their voting laws, including redistricting. And what the Supreme Court said back then is, look, if you're going to put this kind of requirement on states, it has to be based on current situations. And at the time, they were relying on 40-year-old data. What had happened 40 years ago to justify still allowing the Justice Department to have veto power. And I think actually the Supreme Court is going to come back and say, you can't, there's no Section 2 violation unless there's current discrimination going on. Well, that's going to toss out a lot of these districts because in many of these cases, the judges have been saying, oh, yeah, there's clearly a violation of Section 2 because 60 years ago, there was discrimination going on. When right now, in the past, decade, 2 decades, there's been no discrimination happening.
So what does it look like, let's say that this that the Supreme Court decides in the way they seem inclined to at the moment? How do those districts actually wind up changing? Does it vary state by state?
It'll be state by state because in every state, the Constitution gives the power to the state legislature to do the redistricting. We just saw that recently, as you know, in Texas. There's just a handful of states that have changed that, like California. California, a number of years ago, voters there actually passed a referendum taking the power away from the state legislature and establishing an independent redistricting commission to draw up all the districts, which is why, as you know, Governor Newsom said he's going to get Texas because Texas just did all these new congressional districts, right? And their legislature has come up with a new plan to eliminate some of the Republican districts in California, but they can't put it in place because they have to put a referendum on the state ballot in California and get voters to approve not only this new plan, but overriding their independent redistricting commission.
So obviously this is a positive development in election integrity.
Yes. Listen, I actually agree with what Justice Clarence Thomas has said, which is race should never be a factor in the redistricting process. Political boundaries should be drawn based on everything like compactness, trying to keep towns and cities together, not crossing geographical barriers, like rivers and mountains. But to use race, to me, is just I think it's not just unconstitutional. I think it's morally repugnant because you are saying when you do that, you believe a person's skin color decides how they're going to think and vote. And I just don't think we are a society like that, and we shouldn't legally allow that to happen.
Hans von Spakovsky, thank you so much.
Sure, thanks for having me.
Thank you to Hans von Spakovsky for his contribution to today's episode. If you want to learn more about the Voting Rights Act of 1965 and election integrity more broadly, you can read more by Hans and his colleagues at heritage.org. While you're there, check out the Election Integrity Scorecard, where you can see just how secure the elections are in your state. You'll find a link in the show notes. Thanks as always to you for listening to Heritage Explains. You can reach out to us with any thoughts, questions, or suggestions at heritageexplains@heritage.org. Take care, and we'll see you next week.
Heritage Explains is written and produced by Mark Gagne, Lauren Evans, and John Popp.